We're on the record. I'm just looking out. I've muted the microphones at council table. I figure you'd prefer that for trial. So I think if you could use the podium for our first motion that we have today, then we'll proceed to openings at 9:30 according to schedule. We have all 15 jurors are here, so we're kicking loose number 15, the last one chosen. And so we'll go with the 14 others. We have a seating chart that Mr. Schaefer will put them into their seats to start with after we're done with the motion. So we have one motion on for this for this morning, and I believe Mr. Frank, are you going to argue that?
We had a good idea to move the podium, but for now it's a little awkward. I apologize, Ron. We filed this motion just to clarify some points, particularly in light of opening statements. The court's ruling, we thought, was clear and we understood it, but just wanted to make sure that in opening statements, the parties stick to the court's ruling as well, so that something isn't said that's contrary to the court's ruling and could be heard and by the jurors. So we're really, I think our motion is self-explanatory. The statements about Mr. Floyd have to be based on the objective reasonableness standard rather than the subjective intentions of Mr. Floyd and reasonable officers' analysis of that situation. That's the relevant
And can you give
issue.
me an example of what you think should not be said?
That Mr. Floyd was trying or wanted to resist arrest, that he was trying to fight with the officers intentionally, that he was faking or malingering his medical distress. Those are the types of things that relate directly to his subjective state of mind.
Right.
And we've written our motion in a way that we realize those strictures apply to both parties. We acknowledge that, certainly. But it's really to clarify what we see as a potential problem with opening statements. And so I think it's rather self-explanatory. Wanted to bring it to the court's attention so we could deal with it here this morning and just be clear about it.
And the other part of that being, as far as Mr. Chauvin's intent or knowledge, or vis-a-vis that policy that you attached to your motion.
Right. Again, it's an objective officer standard about his perceptions and how they would be dealt with by an objective officer. What he intends to do, right, is relevant because, of course, there's an assault charge and other intent is an element of some of these crimes, and so his intent is relevant, but his conduct is still judged by an objective, reasonable standard.
All right. Mr. Nelson, anything you want to add?
No, Your Honor. I mean, I essentially agree as long as we can.
Hold on. I gotta get you. Okay, go ahead.
Again, Your Honor, it's just simply stating the objective observations of the police officers and of the people who were there. I don't have an issue with that. I agree that, per the court's ruling, that Mr. Floyd's subjective internal process is off limits.
All right. And maybe I can give an example, because like most of the judges on this bench, I'm fairly strict regarding no argument in opening. As far as Mr. Floyd, obviously description of appearances, I think even to the point of saying he appeared to not be complying, I think that's permissible because someone will testify to that, but they cannot say he was resisting, he was, especially in opening. Those are conclusions, those are inferences drawn from his behavior. So when witnesses are testifying, expect that they will talk about what they observed as far as appearances. Sometimes it has to lapse into it appeared to be resistance or non-compliance. But to say that he was is an inference from the behavior. I know this is a fine line, but just so you know kind of where I would draw it. As far as Mr. Chauvin, at the scene, there's this policy in place. Certainly it is permissible in opening to talk about the policy and how an officer on the scene has to follow this policy, make an assessment. And I think if you get to the point of saying the word should is where you get into inferences. For example, if in opening you were to say, Mr. Chauvin should have made this evaluation, that's argument. But to say this is the policy, this is what every officer on a scene should do, that I think is objective, and it is, and then you can talk about the behaviors on the scene. It sounds like I'm splitting hairs a little too thinly, but I think you kind of get the gist of it. Any inferences you draw are argumentative, and so that shouldn't be done. But a description of the policies that were in place that bound any officer who's out on the street responding to an arrest, all that is appropriate in opening and as far as testimony. Anybody need any clarification beyond that? Okay. A couple things. We are going to try and stick as much as we can to the 9 to 9:30 is going to be to argue any legal issues that come up, because invariably legal issues come up. I don't want to move up too much the jury start time because of the process of getting here into the building is a little complicated. So I'd prefer that we continue with the 9 o'clock. Plus we will go to 12:30 each day in the morning. And if you do the calculations between our argument on legal issues from 9 to 9:30 and that with our 20-minute break, that allows for essentially 2 hour-and-a-half blocks of time in the morning. And in the afternoon, obviously, I'll tell the jury that we'll be going generally from 1:30 to 4:30, possibly 5 o'clock. If it's possible to keep a witness from having to come back the next day, I would prefer to go later in the day than to have them come back the next day. But we can talk about that, and we can have chambers conferences. Generally, I'll be here by 8:30, at least by 8:45, if you just want to have a chambers conference about logistics, nothing substantive on the record. So I'll be here if you want to come back at that time during the daily schedule. Other than that, since we have our jury waiting, we might start today at 9:15. Now, having said, I want to stick at 9:30. Since we have all 15, we're going to be cutting one loose. I think we can get started around more 9:15, but I'll give you all a break until, let's say, 9:20, and then we'll see if we can get the jury set and get rolling. All right, we're in recess.